My name is Michael Young, and I'm an estate litigation lawyer. In this video, I want to talk to you real quickly about undue influence. Essentially, undue influence is a means to overturn a will, but it can also overturn a life insurance or account beneficiary designation. It can also be legal grounds for overturning a document such as a deed. But what is it? First of all, undue influence is typically not so overt as you may have seen in the Godfather movie of an example of somebody putting a gun to somebody else's head and saying either your signature or your brains are going to be on this document. It doesn't happen that way in real life, not for the most part. Typically, it's more subtle. I'm going to read from you from the Texas pattern jury charge regarding undue influence. And under the pattern jury charge, the charge that the judge or a jury has to answer if there's a case involving undue influence, the charge will say undue influence means that an influence existed and was exerted. The influence undermined or overpowered the mind of the decedent at the time they executed the document, and that they would not have signed the document but for the influence. Now, the Texas Supreme Court has set out various factors for courts to analyze to determine and evaluate an undue influence claim. And some of those factors that the Texas Supreme Court has discussed include the circumstances surrounding the execution of the instrument, the relationship between the grantor and the grantee. In other words, was the grantee of the document a spouse or a child, someone who's the natural object of their affection, or was it a stranger or a caregiver or somebody else? Next, the motive, the character, and conduct of the persons benefited by the instrument. And this just looks once again at the surrounding circumstances to evaluate, did the person who obtained the document in their favor, did they do something untoward, or did the circumstances look a bit shady? Next, the participation by the beneficiary in the preparation or execution of the instrument. And in simple terms, in the case of a will, did the beneficiary of the document, the person that's being accused of unduly influencing the decedent, did they arrange for the lawyer? Did they take the person to the lawyer? Did they sit in on the meetings? How involved were they in both the preparation and execution of the will? The words and acts of the parties, the interest in and opportunity for the exercise of undue influence, and importantly, the physical and mental condition of the grantor at the time of the instrument's execution, including the extent to which she was dependent upon and subject to the control of the grantee. Now, this is important because capacity, mental capacity, is another grounds for overturning a will or another type of document. But capacity and undue influence are technically separate. Technically, undue influence presumes that the grantor had sufficient mental capacity to execute the document, but they were pressured into executing the document in a way that would be considered undue influence. But practically, when you look at undue influence, one of the factors is involved is the mental and physical condition of the person who executed the document. Were they in such weakened mental or physical condition that they had difficulty resisting the overpowering of the urges or the entreaties or the circumstances of the person who wanted them to sign the document? Now, one thing that's very important with undue influence claims, it's not enough to show that a person exercised undue influence because they had motive and they had opportunity. You're always going to have motive with the grantee of a document. If somebody is leaving you something in a will or they're leaving you property in a deed, there's your motive. That's almost always going to exist. And you're almost always going to show opportunity. In any kind of halfway decent undue influence case, you're going to be able to show that the person that benefited from the document had knowledge of it and probably had at least some involvement or at least an opportunity to be involved in the preparation and execution of the document. But that's not enough. Just showing those two things is not going to get you an undue influence finding, particularly in Texas. what you need to show is that the level of the influence was so high that it essentially overpowered the will of the testator or the maker of the document. Now, the facts and circumstances of every undue influence case are different. And oftentimes you're going to have to rely upon circumstantial evidence. And while that may not be as powerful as direct evidence, that's okay. The Texas Supreme Court says many times you're going to have to rely upon circumstantial evidence, but it has to be more than just motive and opportunity. And you really need to show more than someone asked them to do it, or someone was really eager for them to do it, or they sort of begged for them to do it. You really need to show that they were in a position of power and influence over the maker of the will or the deed, and put the grantor or the maker in such a position that they felt like they had no choice but to execute the document.